great to be here. It's great to be connected to Macaulay and Asbury. And as Mike said, this idea started over 10 years ago. And it started with a big idea over a couple of glasses of wine and beer. And the thought was that there was something better to do in the trust industry. There was something different that needed to happen. And that the traditional models weren't working anymore. Too much conflicts of interest, too much lack of control, quite frankly. And so we're going to talk about some big ideas and some big concepts. And we're going to talk about the question of privacy and asset protection. And we're going to define that. And then we're going to talk about how to get it in a transparent world. But before we do that, we have some friends here. Mr. Matt Kelly, you've been in this presentation for like 10 years, right? You could do this presentation. Matt's an attorney in Lancaster. You were an early adopter. Matt's an attorney in Lancaster, and honestly, I think but this is going to be a little different presentation. But really, what's happened in the last 15 to 20 years is this advent of modern trust law, which has completely changed the landscape of how we look at trusts and how we plan for people. And so that's what we want to talk about today. And then we're going to transition into another planning tool in addition to trusts. My friend John Fisher and Juan from Lombard International, the largest private placement production company in the world, literally the world, whom we've recently partnered with, is going to talk to you about another planning tool in conjunction with trusts that achieves, as an alternative, the same kinds of things we're going to talk about today: asset protection, privacy, control, and tax efficiency. But let's begin here. Somehow or another, the United States has become a tax haven and a privacy haven. It's become the jurisdiction of choice for international families who need and want protection. Could anybody in this room predicted that 10, 15 years ago, that it's the United States that's a tax haven now and a privacy haven? And we're going to talk about why. And the reason why I begin with this is because it isn't just the United States that brings us the asset protection and brings us the privacy. It's also specific jurisdictions within the United States. And the point I was attempting to make, if the world sees the United States as a jurisdiction to come to for asset protection and privacy, then even within the United States, we need to understand how and where we get that. So why are people coming to the United States? Very, very quickly. International families are coming here because of education, marriage, business activities. The presumption that anybody coming to the United States who wants asset protection and privacy doesn't make them nefarious, doesn't make them bad people. So we need to kind of get our minds clear about that. Tax and privacy issues. We're talking about today tax planning, not tax evasion. We're talking about privacy, not secrecy. And we're talking about asset protection and legal means of having things happen properly. You know, the uncertainty of the pandemic is still there. Even though we're transitioning out of it, so many families are looking for certainty in a world that became so uncertain. And that's where we come in at Bridgeford Trust. How many of you are familiar with the Pandora Papers? Raise your hand. So for those who are not, it was a massive data leak, $11.9 million confidential documents that really tainted the industry. And when I say tainted the industry, it's the industry that we're all in, tangentially or directly, which is serving families, finding solutions, providing asset protection, providing privacy, things they're entitled to, and we're going to get to that in a moment. But the Pandora Papers basically pulled names into the public sphere of people who were doing clever planning. And unfortunately, it focused a lot on South Dakota. But the reality is there was no proof of wrongdoing by any of the individuals who were in this Pandora Papers. Although it cast our entire industry in a negative light, somehow presuming that we're aiding bad people. And that's what we're here to talk about, because the question is, what is the rest of the story? What is going on? What is happening from a transparency perspective? I opened the conversation with, well, we want privacy. We all would agree, right, that we're entitled to privacy? Right? We'd all agree with that. We all would agree we're entitled to asset protection. But we also know that there are nefarious people in the world, and we also know that sometimes people try to take advantage of laws in a way that's not ethical or outright criminal. So there are things like CRS. It's a world reporting standard, meaning that countries share information with one another. The United States hasn't signed off on it. We have FATCA, which is our way of rooting out nefarious individuals. And it's just a matter of doing background checks, and that's the important aspects of it. So this happens in conjunction with our ability to give asset protection and give privacy. And there's some key differences, but the point is these are part of regimes that are happening not only around the world, but now here in the United States, to attempt to gather as much information as possible to protect against nefarious activity. However, the question is becoming, are we going too far or not? Something called the Corporate Transparency Act is this idea of having to divulge and reveal beneficial owners in certain circumstances, what hasn't been the case before. It's been passed as a law, so to speak, but it hasn't been implemented yet because there's so much confusion over it. The reason why I mention it here is it's going to impact, at some point, the financial industry in the United States. This is really the United States' response to the international disclosure mandate that I talked about a moment ago, CRS. So what we're seeing is a more and more transparent world, which flies in direct contradiction to what I just said a minute ago, which is, aren't we all entitled to privacy? So the question then becomes, well, how do we get it? And here's the answer. Choosing the correct trust jurisdiction is as critical as a decision to create one in the first place. So the answer is figuring out where to go, and that's really what we're going to talk about for the rest of today, or for the rest, as Mike said, the rest of today, at least the next before lunch. But there's a race in the United States. There's this great evolution of modern trust law, as I said a moment ago, that certain states, South Dakota, Nevada, Alaska, Wyoming, perhaps, they become top-tier jurisdictions. What makes them top-tier jurisdictions? They have asset protection. They have the ability to have trusts in place forever. It's a tax play. Trust taxation, we're going to talk a little bit about that. What does that mean? Why does it matter? Privacy and modern trust laws. What I want to focus on today primarily is asset protection and privacy and what that means and why we're entitled to it. Because it's legal in states like South Dakota, and it's appropriate in states like South Dakota. Remember the movie The Firm? It was Tom Cruise, right, or whatever, where it was all about offshore, right? Offshore asset protection. People went offshore to get asset protection. Well, 20-some years ago, maybe longer, I think may have been Delaware, said, well, we can create the same kind of protection here in the United States. Don't need to go to Cook's Island. You don't need to go to Bahamas. And quite frankly, it became such a haven for criminal activity that it actually had a negative connotation, which is why these transparency rules are coming online, because they were abused offshore. The United States comes to the table, top-tier trust jurisdictions come up with a similar approach. Self-settled asset protection trust, it's unique because it keeps control where it belongs, which is with the settler. Settler can maintain rights to income. But here's the point of this. Here in the United States, a family who's properly vetted and is not nefarious can actually obtain a tremendous amount of protection from creditors, from lawsuits. And the question is, or if I'm you would say, well, does this really work? And the answer is, it does, 20 years later. There's a case right on point out of South Dakota called Cleopatra case that made it clear that these provisions will work. Where they failed is when somebody was trying to be fraudulent. Well, that's not who we deal with. That's why we have these background checks. So having asset protection right here in the United States and right here out of South Dakota is compelling. They're not all created equally, these states. And it's important, and the devil's in the details on this stuff. There's a background, or there's a look back, and every state's a little different. South Dakota is one of the shortest, and it's 2 years. So not only can you get asset protection, and not only are people coming to the United States, but the point now is, well, but you got to look at the right states, right? You got to find the right jurisdiction when you're doing this kind of planning. You can use them in lieu of prenups. You could, or in conjunction with prenups. It's a very powerful tool to have asset protection, which again, we are entitled to. I mentioned the Cleopatra case. It was a very strong case of the South Dakota Supreme Court. And it was made very clear that California was not going to be able to enforce or otherwise pierce a South Dakota trust. It happened to be a marital case. You know, a large settlement came out of a divorce in California, and they came to South Dakota, went to South Dakota court, and they said, no, it's not going to work. That's why we call it asset protection. And the Supreme Court of South Dakota wrote kind of a blistering opinion. And it was all about constitutional principles. And California doesn't have any jurisdiction as long as the trust is created equally. So you see how important this jurisdiction conversation becomes, because it matters in the United States because there's something called separation of states, right? The federal government can't tell certain states what to do. When South Dakota became the first state in the country to abolish the rule against perpetuities and allow a trust to live forever, the federal government couldn't do anything about it. And that's a good thing. That's what we want in this country. So when we talk about, and I mentioned it before, I draw a distinction, an important distinction between secrecy and privacy. At Bridgeford, we do not talk about secrecy. We don't aid in secrecy. We don't get involved with that. But we do talk about privacy. And I love this quote from Forbes because it explains sort of the difference. Sure, we'll tell the government, we tell the IRS what's going on, but our government isn't going to give that information to the Mexican government. And they're adamant about it. That's what that CRS thing I was talking about earlier. So their answer, as I said, is this Corporate Transparency Act, right? A little less onerous, but still an attempt to get some information. But the point is, we still have secrecy. And unequivocally, South Dakota has been considered to have the strongest privacy laws in the country, and so strong and so compelling that it has attracted the attention of international families from literally all over the world that come into South Dakota to get privacy. So let's define what I mean now by privacy. I've been playing around with that word now for a couple minutes. What do I really mean by privacy? There are two aspects to it. One, quiet trust. Matt, with one of your clients that has $100 million, do you think they want the kid in college to know that they're a beneficiary of a $100 million trust? Probably not, because they're not going to go back to college in the fall if that's the case, right? So this is a mechanism for families to control information about the trust. Only really codified in South Dakota. Delaware talks about an option. It's not as clear. It's not as clear cut. And that is driving so many large families into South Dakota, because why? Control. I've said that word, 5 times already? I'm going to say it another 25 times. It's control. It's a control issue. Shouldn't you be allowed to control information about who knows about the existence of your trust, even with regard to your own children? In most states, you don't have that choice. In most states, a kid turns 21 or 25 or whatever it is, and a trust company like Bridgeford has to tell the kid of the existence of the trust. And often, it destroys families, quite frankly. We all know that story over 3 generations when people have too much money. Sadly, I didn't have that problem growing up. So, the other aspect of it is this idea of keeping public information or keeping private information out of the public sphere. Meaning, a lot of you might not know this, but in Pennsylvania and most states, if you're involved in trust litigation, fiduciary litigation, that becomes public record. That goes on a public docket and it's searchable. Meaning the names of the beneficiaries could be discovered, who's managing the money, in some cases how much money is in there. And a lot of people don't realize that. And I only know it because I practiced in that area. I did some litigation and it was amazing how much became public. In South Dakota, never becomes public. It's sealed forever. And most states, it's completely open to the public, as I just mentioned. And Delaware has they seal for 3 years, but the difference there is that you have to have a judge agree with you. Well, sometimes judges don't agree with you, right? So if you can't convince a judge you need privacy or secrecy, well, not secrecy, privacy, then you're in trouble. So this is what drives people into the United States and particularly into South Dakota. And, the idea of privacy versus secrecy very quickly, we're not in the business of trying to capture nefarious families, as I said already. So part of that, making sure we don't do that as an industry, is something called KYC, Know Your Customer. And it's a powerful way of going through and doing world checks and background checks and verifying passports. That's how we do it to avoid the bad actors and the problem people. South Dakota Division of Banking has taken a very hard position on making sure there's uniformity around this and how all the trust companies are doing it the same way. And that is important. And that has kept South Dakota, up until the Pandora Papers came up, out of the papers, which is why the Pandora Papers are so offensive, because it was misreported and it gave an impression of an industry that was wrong. Why? Because I just told you, we do our homework and we make sure these families are real and they're not a drug cartel somewhere out of Colombia, because we're not going to deal with those families. And there's a way to figure that out. It's called KYC. And it's amazing because I have become shocked at those who have somehow criticized the industry that we're all sort of tangentially connected to, whether we're an attorney, CPA, trust company, whatever, if you follow the rules and give somebody asset protection or privacy or taxation savings, which we're going to talk about briefly in a second, and yet somehow people are writing articles saying we're bad people. Matt Kelly's a bad guy because he figured out how to follow the rules, right? It's just chess. That's all it is. And everybody knows, whoever knows the rules of the game better is always going to win. And that's what this is. So none of this is illegal. It's all completely appropriate. And it's become a bit frustrating as how the industry has kind of taken a turn in a different direction, in my opinion. So we talk about, and I want to just sort of touch on this because it's certainly important for Pennsylvania residents. The idea of choosing the right trust jurisdiction isn't just about asset protection and privacy. It's also about taxation. There's court cases that support the idea that if you go into a state like South Dakota or Delaware or any of the other top tier trust jurisdictions, you will save on taxes. You will save potentially forever on taxes because the trusts never can be dissolved, never have to be dissolved. That's what the rule against perpetuities told us when we were in law school. At some point, a trust has to end. Why? So the federal government can what? Take its tax, federal tax. The Dynasty Trust was born in South Dakota. I also think it was the birth of modern trust law in 1983. For a family of any size, it's compelling to be able to keep these assets in trust and away from the federal government taxation. And that isn't all of it. I mean, there's another way of avoiding taxation inside of the trust. Undistributed income, we can avoid taxation on undistributed income. Again, only a little over 3%, but if you're talking about a $30 or $40 million family or $1 million family, that's money that you can save just by moving it into another jurisdiction. And it's legal and it's supported. And the Supreme Court has looked at this and says it's just fine. And the case is called Kasner, and it was a pretty big case in our industry. So going back to the idea of control, going back to the idea of all these big ideas in modern trust law, this isn't anything that is illegal or inappropriate. And it's so easy to do just by looking at the right jurisdiction. So much has changed in the last 20 years or 30 years. It's amazing in the trust industry. I say this all the time. I did not enjoy trust in estates when I was in law school. I thought it was kind of boring, bit stodgy, I guess. And then now I grew up and I own a South Dakota trust company, and I'm wildly passionate about what we can do. I mean, these topics are interesting. These topics are germane to every one of us in this room, and they didn't exist when I was in law school. None of these things existed when I was in law school. And this is the idea and the concept of modern trust law. And I want to focus on one aspect of modern trust law that makes all of this even more palatable for you and your clients and your families and the people you work with. Because what do you think is the biggest block to people establishing a trust, an irrevocable trust? Just think about it. What do you think they're most worried about? Toss it out. Anybody? Legal fees. Yeah, but I talked to Matt Kelly about that. Control, loss of control. The old paradigm still exists, but it's old and it's stale, and I think it's breaking down, is a bundled approach. You think of, and I'm not knocking anybody, I'm just saying you think of a Fulton Bank, you think of a PNC, you think of a bank in New York Mellon, where the trust company and the asset manager is under one roof. You create an irrevocable trust, all of a sudden the family, loses the control. Then along comes something called a directed trust as a direct industry response. And this is, to me, so exciting because it's a legal response to a problem that large families had. They were tired of being told who was going to manage their money, how they're going to get their money, which jurisdiction it was going to be in. And so along comes this, I think, revolutionary concept which says, no, we're going to break all this apart. And family, you can have Bridgeford be the trustee if you want, and you can have somebody else manage the money. That really is a game changer. Can you see why it's a game changer? Because it changes the whole power dynamic. It actually reduces the power of a trust company. And to me, that's a good thing. It takes the scary notion of what is an irrevocable trust away out of, it's not scary anymore, meaning you can do a lot with. I don't even think irrevocable means the same thing anymore because of these modern trust laws. And simply how it works is it's just a breakdown and bifurcation of duties. It's a legal separation of power within a trust administrative aspect of it. And it has changed the industry radically. And we've embraced it at Bridgeford. We don't manage money at Bridgeford on purpose for that reason. It removes conflicts of interest in our industry that has been rampant from the first trust company bank that decided they were going to manage money and be a trust company at the same time, and also sell you insurance, and also walk your dog and try to get you to buy everything else they're trying to sell you. It doesn't work, that model. And I'm not attacking my friends that work in those organizations. There is just too much conflicts of interest, and families figured it out. And then there's an industry response. They wanted something better. And states like South Dakota said, all right, we're going to give you something better. And it works, and it removes so many other problems. Another aspect of modern trust law that goes in conjunction and hand in hand with the directed trust is this idea of a trust protector. It's another control mechanism. It's extremely powerful. It has way more control than the trust company, which is why we call it the super trustee, and it gives the control back again to the family in terms of where it belongs. So we're in a whole new world, and we talk about it in terms of paradigm shifts. And what comes next for families when they start to understand, hey, I just go to South Dakota, or I just go to Delaware, and we can do some things that make sense. So I'm moving around because I don't want to get into too much of the idea of don't want to go too much into more of modern trust law today, because I want to focus on something else. Because I've already told you we can get asset protection. I've already told you we can get privacy. And I just explained how you can do all this without losing control. And you can also get tax planning without losing control. So if you accept everything I just said is true, if you believe everything I just said, isn't there then a duty on the part of an advisor to talk about these alternatives? What do you think? Well, I believe there is, but it's easy for me to say that because it's self-serving. But there are court cases that suggest it. There's actual codified language in the Uniform Probate Code, and I'm not going to read that to you, but points out that there may be a fiduciary duty to do this. This isn't just a funny conversation or interesting conversation at a country club over drinks. This is real. And there's real damages if you don't do it. The tax opportunity alone, proper legal tax planning, that's measurable. You can measure how much money you paid to the government that you didn't need to because you were in the wrong jurisdiction. So if your advisor didn't bring it up, is it malpractice? Scary word, but is it malpractice? I would argue that we're getting closer and closer to it being definitively malpractice. It may even be considered malpractice per se, which means you don't need to prove damages, right? So this is how compelling this is becoming. And there's multiple aspects of laws that govern fiduciaries and trust companies. This is a different area. It's a restatement of trust. It's something that we learn in law school. It says it again there. If you know there's a better jurisdiction, it is not only just an attorney or a CPA, it's also me. My job, our job at Bridgeford, is to do the best we can, every trust company is to do the best we can to protect the assets, to keep things private. All these big ideas I've been talking about, that's our job to be able to do this. So if I'm a trust company in New Jersey, and I know because I am paying attention to the world, hey, wait a minute, these assets would be better protected in South Dakota or Nevada or Delaware. As a fiduciary, do I have a duty to move it? Now, it's counterintuitive because it's going to ruin my business in New Jersey, right? So of course I'm not going to do it. Conflict of interest again. So this industry is going in a direction that I adamantly believe. I mean, Harvard Law Review years ago, right when we were starting Bridgeford, 10, 12 years ago, wrote an article posing this question. I think we're getting closer and closer to it. This is not hyperbole. These are real decisions. There's real consequences for making the wrong decisions. And it's something that we've been focusing on a lot. And so before I transition to an introduction of my friend John and talk about where we now go, I want to remind everybody where we've been. We've talked about 4 areas of planning that exist because we chose the right trust jurisdiction. Tax planning, asset protection, privacy, control with the directed trust and the trust protector. Powerful stuff. You can't get most of it in Pennsylvania. Can't get it in New Jersey. You have to go to these top tier trust jurisdictions. So that's the thematic segue, because trust isn't the only way to achieve those 4 things. Which brings me to private placement life insurance and a quick introduction of John. John Fisher and I met many years ago when I was at Bank of New York Mellon, and he had fairly recently started from scratch a company called Philadelphia Financial. Based where? Philadelphia. Come on, guys, stay with me, come on. And he, literally from his basement, created what turned into Lombard International, which is the largest, I said earlier, private placement life insurance producer on the planet. And he did it basically with a team of people all those years ago. I love the story because it's a similar story to Bridgeford. You know, Bridgeford's not, he's going to give you some big numbers at their size. I mean, we're going to well exceed $10 billion under assets under administration very, very quickly. We have well over 1,000, approaching 1,500 trusts. We started from scratch too. There's a certain passion. And why did we do it? Well, sure. I mean, everybody wants to start a business and be successful. Why I think we both did what we did is because we were passionate about big ideas. Because there's a bigger way to do something, a better way to do something. And it isn't just about the money, it's about concepts. We're not here. And when we speak, when we go around the country, and we have an office now in Miami, we're gonna have an office in California by the end of the year. I'm not pushing product. I'm not trying to sell South Dakota. I'm trying to talk about concepts and get people excited about what they can do. They don't even know what they can do because sometimes their attorneys don't know or their CPAs don't know, which goes back to the question, well, does that malpractice if they don't know? And I believe it's going to be. So the transition to private placement life insurance is another way, either standing alone or in conjunction with trust planning, that brings you exactly what I just talked about. And so it's a perfect marriage. The marriage with John is the idea of putting together big picture concepts to do something huge. With that, before John, I want to introduce Helmer Arizmendi, who's in the back. He is the president of Bridgeford International, which is now a registered insurance agency. Helmer is a lawyer by training. He's based in Miami. He is known all over the world as an expert in private placement life insurance and in planning. And I call him a rock star, and he really is because he's known everywhere he goes. And he's leading that as a newest addition to the Bridgeford family of companies. And the engine behind it is private placement life insurance. With that, John, please come up.
A lot of the things David shared with you are very similar to what we have available to us through this vehicle we call private placement life insurance. We started this company 30 years ago. The tenet was, what are the unique aspects that an insurance company can bring to bear to clients? And David made the reference about trust departments and trust companies. And he talked about how they bundle things. And I would suggest to you the same thing happens with an insurance company. So insurance companies have 5 unique things that they make available to their policyholders. We have unique tax treatment. Maybe better in some instances, in other instances it's not, but it's unique. We have unique capital treatment, so how things get dealt with on a balance sheet for certain corporations. What does it look like? Is it a more favorable capital position? We have access to investments, unusual investments often. We have the notion of risk pooling and the advantages of risk pooling. So we take a number of lives, we aggregate them, and we arrive at a risk or a mortality associated with life insurance. And then we have certain guarantees. They might be either synthetic or they may be true guarantees from the insurance company. So those 5 things are what make an insurance entity itself unique. These are life insurance companies. It's not unique to Lombard. This is unique to any permanent life insurance company in the United States. What we do at Lombard is we disaggregate those and we suggest that you should pick the types of things that you want for your purposes. What is the most advantageous thing for you? Similar to what David was saying. So we talk about jurisdictional risk as well, and we look at things like what states have a favorable premium tax rate or premium tax regime. One of the things in life insurance is a lack of transparency often. And that's another tenet of what we wanted to do at Lombard. And that is, we want to make sure that there's full disclosure on every aspect of a transaction, including the fact that you pay premium tax in every state when you buy permanent insurance. Now, you might not know that, but you do. And again, that's not unique to Lombard. That's unique to the insurance industry. So what we do is we offer a couple of options. and we offer a group of structures that we refer to as variable insurance structures. So what that means is the variability of the investments resides with the policy owner. So the person that makes an acquisition of a policy lives with the variability of that. If you don't want that risk from an investment perspective, then you would buy something that would be a guaranteed type of product. And that would be a guarantee coming from the insurance company. Now, the upside of variability is that you're not subject to the creditors of the insurance company. You're not subject to the vagaries of the market as far as influences. So if a client does very well with a manager, that's fortunate for them. It has no impact on other clients. And the other side of that, naturally, is if someone does poorly, that's unfortunate for them. It has no impact on anyone else. So the point there is we're not introducing additional counterparty risk. That's important when you start talking about things of this nature. You start talking about the length of a trust, David mentioned. Same thing with life insurance policy, right? It's the same thing with insurance types of structures. It lasts a long time, so you want to make sure you have not introduced any additional risk to this that would not have been there without it. So when we start looking at that, we say we have variable annuity structure. Variable annuity offers tax deferred growth and access. The access is limited to, from a tax perspective, to ordinary income tax. So that's a trade-off. And I want to talk about trade-offs too, because I think it's disingenuous when someone comes up and says, hey, everything is great, and I didn't tell you about the fine print. So I want to tell you about the fine print. So fine print is when you buy an insurance structure and you put investments within the confines of that structure. One of your give-ups is when it comes out of an annuity, it's going to come out and be taxed first on gain at an ordinary income tax basis. Different than if I had a long-term capital gain. So I've traded that off. What does that tell me? That tells me intellectually I don't want to put a lot of long-term capital gain types of structures within one of these policies, right? I want to take things that are inefficient and put them in, because that would be a better way to access this. I'm not trading long-term for short-term gain. Another structure we have is variable life insurance. And as you would suspect, that covers life, right? And that works like any other type of permanent insurance. It provides for a death benefit, and it can also be structured so it's going to grow tax deferred, but it also gives you tax-free access to your money vis-a-vis loans and withdrawals and so forth. So that's another structure. We have a version of that called survivorship, of which that would cover 2 lives. And then we have an institutional structure that we refer to as an insurance blocker, which is a group variable annuity, and that's used by domestically, it's used by things like foundations, endowments, corporate pension plans, municipalities, and things of that nature. Okay? So those are the types of structures that are available. We marry those in concert with the same sorts of concerns that David referenced about jurisdictional aspect of things, the same sort of concerns of privacy sorts of things. And again, I would take great pains in supporting the fact this is not secrecy, it's not nefarious, these are all within the rules. The obvious question then is, how long has this been around? I've never heard of it. It's been around on the books with statutory guidance and with regulatory guidance and tax guidance for well over 50 years. Okay? So why haven't I heard of it? Good question. One of the reasons you haven't heard of it is a lot of insurance companies use these types of structures for their own proprietary investment accounts. Lombard has never managed any money. We don't manage any money in any of our structures or any of our companies worldwide. And we have insurance companies, they're all Lombard companies, based in Guernsey, based in Luxembourg, based in Bermuda, and based in Pennsylvania. So I think that's an important aspect as well when we start talking about these things. So what are the upsides of this? Well, the upside is certainly from a reporting perspective. And what do I mean by that? Well, is anyone familiar with the dreaded K1 by any chance? Okay. You hate K1s. People that get K1s hate them. They especially hate them when they've gotten the 4th version in October and your tax return is due in 2 days. And it's still not right. When you have a structure like this and you utilize, the insurance company is making an investment on your behalf. So consequently, reporting goes to whom? The insurance company. Insurance companies' taxation is predicated on one simple principle, and that is when we invest money on behalf of policyholders, we pay no tax. Is that unique to Lombard? No. It's insurance regulation. So we pay no tax on that. So consequently, all those K-1s come to us. What do you get as a policyholder? Nothing unless you make a withdrawal. Then you would get a representation that you made a withdrawal in the appropriate amount. That's what you would file on your tax return. Other than that, I know my accounting friends will be sad to hear you won't have to deal with K-1s. That's a good reason, and that's a good benefit of doing this sort of thing, similar for 1099s and so forth. So we've talked about, this has been around for 50 years. We talked about the guidance is long and storied. We talk about protections and counterparty risks. So the protections are such that you're going to have the creditor protection. Oh, I heard that earlier today from a trust side of things. You're going to have certain protections as far as creditor protection, as I mentioned. You're going to have protections from your privacy. You'll have privacy. And that's important because when you go and make investments, you don't need everybody to know what you're doing. So when we open a policy for someone, the policy is identified by a policy number. Okay? We're not identified by name. We certainly know who you are, but we use it to make sure that that is an investment made on behalf of the insurance company for a specific policy. What do we use these things for? Well, we use the annuity for people that are charitably inclined. Okay? You can put your money in here. You can direct it through the structure, and then at the end game, if it's ultimately a charitable gift, what have we done? We've made the charitable gift bigger just by virtue of eliminating and reducing the taxes associated with it. We use these things for transfer, wealth transfer. We use it for estate planning. We use it for income tax planning. These are all aspects of what these various structures allow you to do in full and complete compliance with every law. This is called private placement. That means you're not registered. It doesn't mean you're not regulated. I will assure you we are regulated. We're regulated by our friends at Treasury in the form of the IRS. We're regulated by the Securities Exchange Commission because this is a security. So we deal with them. And we also get the added privilege of dealing with 50 independent state insurance departments. And that about goes you. But we deal with them all. So to say it's not regulated could not be further from the truth. Okay, so that's important too. The people have to know that. Now, I usually start off with, but I got so nervous after following David that I forgot. I normally start off with the only thing most people know about life insurance is that they don't want any. And I think a lot of that is because we don't understand why we have it, why we need it, what the value is. And it's because of this opacity. It's this lack of transparency when you go to look at something. You don't understand, what is it I'm buying? And can I get out of this? And the answer for us is absolutely. When we talk about, what about the investments? When I talk about bundling things, well, I just talked about we want to disaggregate that in this sort of structure. We manage no money. We don't participate economically in any investment management side of things. We don't participate economically in reinsurance. So we have the true professionals, the risk professionals handle risk, the investment professionals handle investments, and we look at the oversight of what this provides to your clients. Do I think it's important that you understand what it is? Do I think it's important that you have an obligation? You have an obligation yourselves first. You have an obligation to know about these things. It's important for you as business people. When a client says to you, geez, have you ever heard about this? You want to be able to speak in the affirmative. Yes, I have. Why haven't you ever brought it up to me? If you don't bring it up, someone else is going to. So I say that not as a threat. I say that so you know what it is and understand how it works, understand the benefits of it. And then as a fully informed consumer/advisor in your instances, you make a decision. Private placement is not for anyone by any stretch of the imagination. But when it is apparent that it's the right thing to do, and I say the right thing to do because this to me is economics and it's math. We look at the value of the tax side of things. You look at the offsets. What do I have to do this? What is the tax treatment I mentioned? the two things I have to be concerned about here when I do a private placement, number one, how an insurance company gets taxed. Well, I mentioned that we don't pay tax on investments we make on behalf of policy owners. That leads us to a very important concept, and it's called investor control, and there are tens and thousands of pages written on this. Juan, lock the door. We're going to cover them all right now. Basically, I can just tell you that what it says is you cannot avail yourselves of the benefits of insurance structures if you manage your own money. So consequently, we have to have an independent third-party manager. You can create an investment mandate with them where you talk about the types of things you're interested in. What you are prohibited from doing is deciding specifically and agreeing to, I want this specific investment, or I want you to sell this specific investment. You can change your mandate, you can change your durations, you can change your risk factors, you can change any of those things essentially at will. But you may not direct your own money, and we're very adamant about that. This is all we've done for 30 years, so there's no amount of money, I can assure you, billions of dollars, there's no amount of money that we're risking the franchise on anything like that. We do not do that. So that's an important aspect for you all to know as well. Investments, I'm often asked, what type of investments can I include? Well, the types of investments you can include are basically limitless, okay? You have to adhere to this investor control document I'm talking about, but you can have everything from private equity to various alternatives, hedge funds, renewables, master limited partnerships, just plain old stocks and bonds, and any combination thereof. So you can have any number of different things contained within one of these structures. When you sell something in the structure, you don't recognize any gain on a current basis. Only when you get rid of the policy, remove it from an annuity, would you end up with any kind of tax change associated with that. Obvious thing now is what about cost, right? And I always tell people when you look at something like this, doesn't matter what you're buying, right? You have the same sorts of concerns. You have the same sorts of concerns. You're buying a car, you're buying a TV, you're buying anything, right? What does it cost? What do I get? What are the benefits? You know, what am I trading off to do it? Okay. So the cost is based on the concept of asset-based charges that are imposed by the insurance company. That's how we get paid. They decrease as the account size raises. They're based on size and complexity, how we start off, what's involved, how do we have to set something up to do that. Investment management's a pass-through, mortality is a pass-through, the taxes are a pass-through, et cetera. So that's your cost. It's really pure and simply that. We have advantages with respect to taxes, as I've mentioned. We have advantages as far as reporting, as I've mentioned. We have advantages as far as protectionism, and we have advantages as far as the investment outcomes. So our time is short. I appreciate all of you attending. I appreciate those of you at home. And we want to just leave you with the fact that looking at a solution like this is one that is incumbent upon you to look at all sides of the transaction. So I have to understand what's happening from investment. I want to understand from a tax perspective. I want to understand from an ownership perspective. What's the responsibility of where I base this? What's the responsibility of the trust company? These are all things that are relevant. So with that, I thank you for your attention, and I wish you a great rest of your conference. And if anybody has any questions, we're happy to address them.
Thanks, Jim. So, asset protection, privacy, tax efficiency, control. These things are possible, and we can do it all without conflicts of interest.